I'm Russell Knight. I wake up, I brush my teeth, and I divorce people. I'm really, really into this. If any of you practice family law, I know you're Googling your questions, and I know exactly where you're going to. My website. It's got 750 articles. I do them law review style, all the citations. Why? So that I can cut and paste the case law, the statutes, the rules. I can post them into whatever I'm writing. Not really me anymore, because I've got 6 other attorneys that work for me, and they all do that. That's how most people know me, is through these articles. So one thing that we bump up a lot against is trust issues, because family law attorneys typically don't know anything about it, and I kind of stand in their number. So what I'm going to be doing today is I'm going to be talking about how trusts and estates interact with divorce in Illinois, and it's really, to be honest, it's mostly theoretical because I don't practice trust and estates. I'm not familiar with it, but what I do know is I know how to read a case, and I've read every case that is associated with trust and estates and divorce. And there's 4 big factors that we're going to cover here, okay? The 4 things we're going to do is how trusts and marital assets interact with each other. All right, and so we're going to talk about what kind of trusts can actually be separate from the marital estate, and what kind of trusts are fraudulent. Fraudulent in intent, fraudulent in design, fraudulent in fact and law. Then we're going to talk about the dead hand policies, where basically the son-in-law trusts, where my schmucko kid's husband, I don't like him, so I'm going to set up a trust that says, maybe if you left him, I'd be a lot happier and you'd be a lot richer. There's a way to do it, and there's a way not to do it. And we're going to be talking about the limbo period, what happens to all these wills and trusts when you start the divorce, but the divorce isn't done. Here in Illinois, you're not divorced until you're divorced. So what happens to all these trusts, wills, et cetera, that you have while you're trying to separate your life from somebody else entirely? We're going to talk about what to do and what to expect and how to protect your client. And then in the aftermath, when that divorce judgment gets stamped, when that piece of paper goes out, there are things that automatically happen by law, but there's not like a switch that goes off and then all these things happen where wills get changed, et cetera. You have to follow up with it, but you also know that you're protected because it's automatic by law. And there's a big one where it's not automatic, and we're going to get into that so that you don't get yourself in a jam. All right, let's get started with these crazy trusts where people think you can protect people by having a trust and protect yourself from a divorce. This idiot is on my social media feed all the time, and he finally got a good suit because people were making fun of him for dressing like an idiot. He says, put your stuff in a trust specifically for divorce. Well, that doesn't work. Here's how trust and divorce really work. As we know, you estate and trust attorneys, trusts are created once the property is transferred. So when the property is transferred, it no longer belongs to the person, it belongs to the trust. Let's see how that interacts with marital property. Marital property in Illinois is property, all debts and assets that were acquired during the course of the marriage. And anything that you get that you can't identify as coming from an inheritance before the marriage or a gift, that is going to be presumed to be marital property. So where do trusts fit into all of this? Because you don't really own it anymore, but you probably still have control over it. So is it marital property? Is it divisible? The court only has jurisdiction to divide marital property. So if you have a trust and you want to keep it non-marital, there's a bunch of stuff you got to do. Non-marital property, to make it non-marital property, it has to be a gift, legacy, or descent, or exchanged for something that was a gift, and you have to be able to track it. And trusts are contemplated as being part of property pursuant to case law. Even though you don't really own it, we're going to get into what trusts are marital and what aren't. So does this mean that you can just create a trust and say, oh, it's not marital property, Judge. Sorry, you have no jurisdiction to divide it. I wish you could. Would have been fair, but too bad, so sad. The trust owns it. This sounds like a genius idea that people all over the world would do. Well, they don't do it. Some do it, typically with Wyoming trusts, and they have to get the wife to sign on it too, and then she has to say, I didn't know what was going on. But we'll get into that. Trusts are not a perfect shield. There's a big, giant case about it, Johnson versus Grange State Bank. It says specifically, if it's colorable or illusory, it's tantamount to fraud. The question is, why did they set up that trust? And we're going to get into what colorable and illusory means, but you probably already know. If you set it up to remove it from the marital estate into another estate, it's bogus. If that's your purpose, was to protect for the divorce, it doesn't count. Let's get into what's illusory and what's not. An illusory transfer is one that takes back all that it gives. So a revocable trust, right? You're the one who can revoke it, put it into a revocable trust, but you can take it back at any time. That's illusory. Colorable transfer is when it appears absolute on its face, but some secret or understanding is that the transfer isn't real. I'm going to put this into trust. My beneficiary, it's irrevocable, but the beneficiary just happens to be my brother. Give me a break. That's not real. That's marital. This is the same thing as a fraudulent conveyance. If you went and took your Fabergé egg and left it at your sister's house, it's not a real gift. Everybody knows you're going to come back and pick up your Fabergé egg after your divorce is done. The key thing is the intent. That's all they really look at, the intent of the parties. This gets tricky because, of course, the people who have the illusory or colorable transfer are going to say, we never meant to do that. The Fabergé egg was always in our family's name. We always wanted to keep the Fabergé eggs. We've got 100 other Fabergé eggs buried in the backyard. They're going to testify that the intent was never to be a fraudulent conveyance. It's pretty difficult to get over, so you've got to make your trusts look really, really clear so that you can be sure there's not a hint of deception. And here's the thing. We've all been in front of judges. They're not idiots. They know when you're trying to transfer something. They know when you're trying to hide it. You're not going to be the only witness. They're going to talk to a financial advisor who has no privilege whatsoever. And the financial advisor is going to say, like, yeah, this is what he's wanted to do. He said that he wanted to divorce his wife. Or here's another question. Was the wife there at the meeting? Probably not. It would be very interesting. Those are the kind of things that make it colorable, that make it possibly fraudulent. Revocable trusts, though, are not per se fraudulent. They can be denied because it matters about the intent. If you gave a revocable trust and it really was in the best interest, like if you gave it to your kids maybe, or charity, and your heart is pure and you can show that, revocable trust isn't automatically folded back into the marriage. And in addition, the spouse can testify to say, this is just regular old estate planning. I put stuff into a trust for my grandkids or what have you. I know that it might look like I did this because I did it 6 months before, but this is a regularly scheduled appointment that I have with my estates and trust attorney. I do it every 2 years, every 5 years, every 6 months, whatever it is. That will prove that the intent was not to defraud, it was just estate planning. Irrevocable trusts are about as safe as it gets. You can't give it back to yourself. You probably can't. You can't have a secret deal with somebody with an irrevocable trust, because your brother might say, I'm going to keep the Fabergé egg. Sorry. But what if you convince your spouse to sign the trust? Honey, we got all this money. We need to put it into this Wyoming trust. It's going to be safe there. You trust me. I trust you. Why don't you sign it? And then we'll see what happens. And what happens is you get divorced 6 months later. Just because the spouse signed it does not mean that the trust can't be abolished by a court order. It depends on how naive the other side is. If the respondent was unaware of the petitioner's consultation with a divorce attorney, she had no attorney, the trust is set aside, the matter is remanded, and the property has to get put back. I'm sorry I did not have the citation, the quote there. It's very unlike me. But there is case law that says even if you sign on, an innocent spouse remains innocent. Let's get into the next issue. Can we tell a will or a trust to encourage divorce? It's void by public policy, not by law, but by case law. But there's a lot of ways around this. Just because something seems to encourage divorce doesn't mean that it really is unconscionable. A lot of times you could just make it look like it's planning. So if a trust said, to my beautiful daughter, I'm going to give you this amount of money, not on condition if you get divorced, but God forbid if you do get divorced, there's going to be extra money that kicks in, and it has to look like you weren't trying to encourage the divorce. And the terms of the will still be valid. If the motive, again, it's all about the intent, if the motive was to protect the child in the case of a divorce rather than to encourage the divorce itself. Wills and trusts when a divorce is pending. There's no separation status in Illinois. You file a divorce, it means nothing. The assets you still continue to acquire are still marital and thus divisible. Can be considered, but there's no line drawn in the sand, so to speak. So typically, wills and trusts during this period, the spouse will still be the beneficiary, spouse is still likely to be the executor, spouse is probably still the agent under a power of attorney. And they remain so during the course of the divorce until you do something different. Can you write your spouse out of the will and be like, I'm done? Sure you can. But God forbid if something happens to you during the course of the divorce, they can still get the elective share. Half if no kids, 1/3 if there are kids. Marital trusts, that's with both people on the trust, is marital money. So any non-marital money that gets funded into a trust, so an inheritance, a gift, money you earned before the fact, and you put it into a marital trust, the divorce court's going to look at that and say, well, you converted that from a non-marital estate to a marital estate. So if it's a trust where they're both beneficiaries of both parties, it's called commingling. And when it gets commingled, the court says you willfully tried to put this money into a marital estate because now both of you are the beneficiaries. Trust income is also income. When kids get money from a trust on a regular basis for the purposes of child support, for the purposes of maintenance, it includes all income from all sources. So they might be making $50,000 and they're getting another $40,000. The court will consider that to be $90,000 of income for the purpose of determining child support and determining maintenance.
But that's only if they get the money, right?
That's correct.
Okay.
So if the money gets pulled back, then we have a bunch of other questions as to, again, if they have access to it or control is usually the two words we say, access or control. So if you hold back the money, it becomes like retained earnings in a business where it's like, well, we get it. You're not depositing the money in your bank account, but it's building there. You still have it. You have access to it. Why don't your kids have access to it? Why doesn't your wife have access to it? But the truth is,
it depends on your access.
yeah, but people don't get that far, to be honest. They're like, oh, well, like retained earnings is always a thing for small business people, and only super rare where people catch on. It's just people hide money like crazy, and with trust, it's actually a terrible way to hide money because everything's written down. You'd be better off starting a business that runs on cash, like a laundromat. And then my section is what happens to your wills and trusts after this is entered. So when the divorce is final, what happens to your estate plan? First thing that happens is there's a statutory revocation so that your will, your spouse is automatically delisted from the will pursuant to statute. You probably want a new will anyways, but don't worry about getting hit by a bus on your way out of the courthouse. When you're divorced, your ex-spouse has no interest in your will. It doesn't matter if the will was made before or after the marriage. It's kind of like, well, I put her on the will before I got married. Why would she automatically be off of it after we're married? Now, the case law says you're off. When you're divorced, there's nothing in any will that you're going to appear in. You're done. It's over. Even if the will was sort of had a non-marital quality. Powers of attorney also automatically get revoked, so you need new powers of attorney as well. Legal separation is I think in reality it's a fiction. Legal separation is the same thing as a divorce, except you're like, I'm just not ready to be divorced. So instead of dividing my assets, we'll set up child support, we'll set up maintenance, we'll set up parenting time, we'll do everything but really be divorced, and even have the option to divide your assets, but you're still effectively married, but you're only legally separated. The only reason someone would ever do that is to basically put a fraud on health insurance and to say, I'm going to stay married to this person indefinitely so I can stay on their health insurance. There's a court order that says you are legally separated. I've been doing this for 19 years. I have filed so many petitions for legal separation. I have never entered one order for legal separation. It just doesn't happen. 6 months later, they're like, yeah, actually, matter of fact, I want to divorce this bozo. Ex-spouses are also automatically removed from life insurance. You probably want to do it anyways because there's probably going to be some kind of fight because the insurance companies will often pay out to the named beneficiary to avoid liability anyways, even though it's supposed to be automatic, and you're dead. You're not there to remind them that, oh, actually I got divorced. So you got to be careful. There's one thing that will not be automatically revoked. Anything that is governed by ERISA, that's a 401k, not an IRA, a pension. The federal law, there's been a Supreme Court decision from 2001 that says the listed beneficiary always gets it. Too bad, so sad. So that's the one thing that absolutely positively has to get changed is the beneficiaries. Everything else, you're kind of off the hook. So what I want you to remember from this presentation, which I know I did way too fast, but we can have some questions maybe. For asset protection, trusts can protect assets, but not if they're really revocable or illusory. The smell test of fraud applies. It's bad divorce planning. There's probably a million other things you can do if you want to isolate some assets, like spending them. That's what most people do. But trusts are just a poor vehicle to try to keep your assets from being touched by a divorce. Your better bet is to make a deal so that those assets that you really want to keep, you're giving away other assets in exchange. People typically, they know they're getting divorced, they know they're going to divide things. The question is what's going to get divided. The business owner always wants to keep his business. So the better strategy, instead of putting a business in a trust, is to negotiate in the divorce saying, you get the car, the house, etc. I'm going to keep the business that you don't even know what it's worth. And even if you hire an expert, how are you going to figure it out? It's just silly, in my opinion, and it comes up very, very rarely. People don't really plan for divorce. They plan to save for divorce, but it's usually the spouse it's usually the non-moneyed spouse that's planning for the divorce. You can think about it, it makes sense. You're the non-moneyed spouse. You're probably more nervous about this divorce than the other person. You don't know where your money's going to come from. So they're the ones that do the planning. But if they have they don't have the money, there's nothing for them to put into trust. So it's rare. It's a terrible vehicle. But if the person insists on doing it, it has to be irrevocable and can't have the hint of fraud at all. For public policy, when you do a will, you can't say that the child has to divorce someone under condition to receive the will, but you can say, if in fact you do get divorced, I'm going to be giving you this extra money because I know you'll need it once you're done with my schmucko son-in-law. And then during the gap, this is a dangerous time. While the will, we talked earlier that the wills automatically get updated, wills do not get updated just because you have a petition for dissolution on file. And it happens all the time where we are in the middle of a divorce and somebody dies, we file a notice of death, and then the person says, well, what happens? I'm like, well, you just inherited all their stuff, for starters, because nothing did happen all the time. Especially, I practice in Naples, Florida too, and my clients are of age, and this is something that frequently happens, and then some person they've been married to for like 6 months, and then they get divorced, they try to get divorced, the assets are still available for probate to the ex-spouse, to this would have been ex-spouse. And finally, post-divorce, the automatic revocation statute catches almost everything, but it would be silly to leave it alone like that, because then it's a two-step process. You'd have to tell the life insurance company, oh, by the way, I'm divorced, don't forget to change my life insurance policy. Why not just change your life insurance policy? So it's a lot of common sense to protect yourself. And the biggest thing that you have to tell everybody, because it can't get undone, is 401ks, pensions, anything retirement related, except IRAs, but do it on IRAs anyways. The beneficiaries have to get changed after divorce, otherwise they still will inherit those assets. So in conclusion, if you really want to remember something, send me a case. I love talking about this kind of stuff. If you have questions about anything with divorce, Google it. One of my articles, I promise you, will come up in the top 3 hits. I think I explain it really well with all the case law, the idea so that you can cut and paste it and use it in your own pleadings. And people tell me all the time they use it and it helps. And if you don't, in addition, I'm super on social media. Please give me a follow. I do funny or interesting videos where I try to explain stuff, not really on the attorney level like the articles do, but sort of for the average person. And I would recommend, I think in 5 years we're all going to have to do it. It's just what people do. They say, oh, I checked you out, and then I checked out your social media. I'm sorry, you had a question?
I do, when you're ready.
Okay, go ahead.
So, question. Parents set up their own revocable living trust
Yeah.
that says upon the deaths of both of us, everything gets held in a continuing trust for our son.
Sure.
Parents die, sub-trust is set up for son, and son gets married,
Okay.
and now son is getting divorced. So and maybe the trust terms from parents said son can have income out of the trust, and when he turns 50, he can take out half of what's in there, and when he turns 60, he can have the other half, but he's only 35 right now. His parents are deceased, and he's getting divorced. What can the judge divide? To what extent can the judge consider the inherited irrevocable trust set up for the son in the divorce from his wife?
In inheritance, there's only 3 things that stay non-marital, no matter when you receive them during the marriage. In inheritance, and the presumption anything you get from a parent is presumed to be an inheritance. A gift, again, it goes to the intent of the donor, like, I'm really giving this to you forever. What's better intent is there than a trust? To my son, to maintain him, obviously it's a gift. It's a gift and inheritance. Or it's assets that were transferred before the marriage, which I think in your scenario, the trust was created before the marriage and as a beneficiary. So the son on all three points is non-marital property. If it's non-marital property, the judge has zero discretion, zero jurisdiction to divide that property.
But and then what about just considering, don't the marital assets have to be equitably divided?
That's
And
correct.
does the husband's, the fact that he has a huge trust fund, does that come into play in dividing
Yes.
what our marital assets?
If they're sitting in a $300,000 house and he's got a $3 million trust sitting there, she's probably going to get awarded the $300,000 house, and she might not get anything else. There's no definition of equitable. It's not a math formula. It specifically says in case law after case law, it is not math related. It is based on the best judgment, and we bring it up all the time. In fact, we bring it up in advance where we will subpoena the parents of people who are getting divorced, asking for the copies of their wills to see what in fact they're going to inherit. Yeah.
Oh my God.
Really?
And I'll be candid with you. It's a leverage move. It's not like that we're really going to tell the judge like he's going to inherit $1 million. That's true, and it's
Or lose the money.
yeah, and it's morbid and it's creepy, but it works. And the client's usually held up on it. There's always one person who's convinced that their in-laws are insanely wealthy and that any day now that this person's going to inherit all of these things. And then it's usually the opposite. It's because their parents have money, they're expecting to inherit. There's one of those people, not good people, that are waiting and think they'll finally be wealthy and happy when their parents are dead. Okay, and they're waiting for that money to come in, and they presume that the other side has the same thing, but they're getting divorced. In-laws hate them. They don't know what they have. That's an excellent question, and I wish I had included stuff like that in my presentation. And I think your analysis is exactly right. Instead of leaning on, there's 14 factors that courts are supposed to consider. The court just has to say that they thought about it. They don't have to go through all 14. Pretty sure it's 14 if I remember correctly. And then but it's really more common sense to say like, all right, well, first of all, what do these kids need? That's step one. Step two, what do these two parties need? And then if someone's going to come into a windfall later on, let's also order or agree to say when in fact this trust kicks in, this agreement is automatically modifiable. We'll treat it as a substantial change in circumstance. Before 2019, if something was contemplated, this would get really complicated. He's like, well, you knew you had the trust, so I got the trust eventually, so it's contemplated. It's not a substantial change in circumstances. We've gotten rid of any idea of contemplation in the statute. Contemplation does not matter. If the guy knows he's going to get all this money at age 50, it doesn't matter. When it hits his bank account, that's a substantial change in circumstance, and you can change it. So the truth is, I think you're right. It's like the judge would probably put it off and be like, he'll be a millionaire when he's 50, not today.
Right.
So come,
And all that can happen.
yeah.
Those orders are always amendable too, aren't they?
Depends. 503, anything under property distribution is not amendable. So the order where she gets the whole house or half the house or what have you, cannot ever be amended. And then if he's awarded something the same way, and it's like, well, now you've got these assets, and your argument would be like, well, I was awarded these assets, and so you can't take the assets as income when they're coming in later on to say, well, now it's income. If he starts drawing down the trust, it's a good question. Is that money going to be income or not? I'm not so sure. There's a double dipping case law that says that the money that comes out of the trust, if it was awarded to him if it was anything else, if it wasn't in a trust, if it was awarded to him, that's not going to count as income for child support. Yeah, but because it's in a trust, he doesn't really own it, so it's not really awarded to him.
Correct.
Yeah.
But that's what I'm saying. I think that the judge in that case would, if anything, consider what income he has on a monthly or yearly ongoing basis, that the court can say, you can choose to defer or leave it in, but you have the right to it. So minimally bring that in for child support or maintenance. Depending on the length of the marriage, in 15 years, the maintenance may be over, so it never really kicks in, because then all of a sudden if he has an asset, that could be considered for a reason to increase maintenance. In 15 years, the children have emancipated, so maybe college expenses. So in your hypothetical, it's actually a good thing that it's 15 years down the road versus the elderly parents that could potentially die in 6 months.
Yeah,
argument.
and
Which actually, if you represent the parents, talking to them about not making it a mandatory distribution.
maybe.
So for
Giving
income-
the trustee much more discretion, that's probably their best way to get around it.
Even for income, I like to say the trustee may, in its sole and absolute discretion, distribute income.
It's a great idea.
Yeah.
A great idea. Divorce lawyers are notorious for kicking the can down the road. They will put in the agreement, we'll just deal with this later. I guarantee you that's what's going to happen, because why fight about it? These people are at each other's throats, and there's one last thing you want to fight about when you can deal with it later. They're going to put it off, my point. Go ahead.
Just piggyback on that scenario, but let's say that in addition of ability to draw, the child itself can be a trustee of their own substance. That's what we usually do. At a certain age, let's say at 30, the parent put in that the child's in control of their own, inherited trust. And they're married, but now they're gonna get divorced. And also it says that at certain ages, like at 25, at 30, they have ability to, withdraw in addition to any income, but for any purpose they wish, because they are their own trustee, right? Let's say 25% of the trust, and then when they're 35, maybe 50% of the trust, but that's a discretion. They can withdraw, but they don't have to withdraw that. those money. So how would the divorce court will look at that then? You know, you have this trust, it's inherited, but yet you're able to withdraw. Now you're, let's say, 35, and you can withdraw 50% of that trust at any time. It tells it in the document.
It starts as being a non-marital asset, but then your real question is, does it become income once he has the power to withdraw it? And it's really incumbent on the divorce attorneys to write down in the allocation, in the marital settlement agreement, what is really going to happen. Is this going to get treated as income in 5 years, 10 years, 20 years, or not? And if they miss that, if they blow that, yeah, it's probably income. The statute says income from all sources. But then the counter question would be like, no, I was awarded this trust in the divorce. But then, how can you award a trust if you don't own it? Yeah, well, yeah.
You know, let's say he's divorcing now. Would the judge consider, I can see, you know, when I practice, I can see the argument being that, okay, now we have to allocate for college expenses, and he has, you know, ability to withdraw $1 million out of this trust. It's discretionary. He's not withdrawing it now because we're in divorce, but yet it says he can. So are we counting it as available asset?
513. This is a great question because 750 ILCS 513 governs college expenses. It treats things completely different. It says capacity to pay, and it's the only time where we rope in the new wife or husband and say, wait, how much money do you have to make this kid go to college? Because if the new wife's paying all the mortgage and the dad has enough money to pay for college, they're going to do that. And so on the same, my thought is that specifically for college expenses, a court's going to say capacity to pay. I don't care if it was an inheritance. You're paying for this kid to go to school. For child support or maintenance, it depends how good your lawyer is.
You're saying a new spouse who's not related to this child, later on, they're going to consider their...
For the purpose of college, yes, only college. Not for child support, not for maintenance.
The question is whether you have the ability to contribute to your kids' college expenses, and if you are a stay-at-home parent earning zero income, but your spouse is providing you a six-figure home, then you have the ability to contribute to your kids.
Really?
Yeah.
And where would they get that money?
From their spouse.
Figure it out is what they'll
That guy gets to pay for college.
Yeah.
Or somebody else's child.
Russell, do you think, just to finish up,
Yeah.
do you think then the judge in the allocation of property would also consider, because he's able to, you know, to take?
Yeah, if he has the capacity, like
Well,
it's,
I think the term is, they're looking for is access, so that's my opinion of what you're saying. So the trust is drafted so that at age 30, the beneficiary has the right to withdraw up to 25%, and that might be $1 million under this scenario.
yeah.
But is not required to, and if the person chooses not to, then it just continues to grow and then let the window shut, or maybe it stays open till the next age at which they can withdraw. So you have the right to withdraw, you don't have to withdraw, but now the
Yeah.
trust says you can take
It won't be divided, but it can be treated as income if you have access to that.
for support and maintenance
Yeah.
as well as college.
Depends really on how it's drafted, okay? If it specifically says that as part of the there's the other assets that are also marital, and if it specifically says in your agreement that any proceeds from the trust will go to my son, to the son, and then the other marital assets get divided, and the daughter-in-law gets more because this trust exists, then you have an argument that taking any money from income as income would be double dipping. But let's say in the converse, you say, it's a trust. Why would I put it in the divorce decree? Because it has nothing to do with it. It's its own thing. You may be in a jam there, because that's income coming from all sources. And if a judge has a choice between saying that kids get to eat or have clothes for child support, meanwhile the son is sitting on the couch doing nothing but living off the trust, the judge is probably going to award child support or maintenance based on that income that comes in. And
That's potential income that they're just choosing not to dip into.
yeah, and there's the first analysis is child support or maintenance appropriate? The second analysis is it is. We follow the guidelines, which is a math formula. And the third step is if we don't follow guidelines, the court has to make a deviation and say why they made it. And that's obvious for the court. The court would say, well, this guy has access to all this money. That's why I'm deviating. I'm going to say, the court could probably say, listen, this guy is no good. He doesn't take the money out. I'm ordering you to take out the money now in $100 grand, and we're going to put it in a 503G trust. Mom's now the trustee, and mom can withdraw the $500 a month that she wants every month as satisfaction. We're not going to be chasing this guy all over town.
But if part of what the adult child is taking out of the trust at age 50 was part of the original inheritance, it's not really income, it's principal now. That principal, maybe when the parents died, there was $4 million in there. That's the principal amount. He doesn't take it out right away.
That's a fine.
It grows,
Yes.
And so the growth is income. If he takes it out, that is income. But if he just leaves that 4 million in there and then later on he takes it out when he's allowed to, that's not really income to him. That's his original inheritance.
That's a fine argument, and it doesn't always stick because they do this with 401ks, where there's the case law as of today. I don't think this makes sense, but if a withdrawal from 401k after you've retired for the purpose of for the purpose of maintenance, that is not income, is what the case law says. But for the purpose of child support, it is.
Generally speaking, the judges are always going to award child support.
Yeah.
They're, you know, if you can establish that the party's lifestyle is remaining the same, you know, post-divorce, that the children's lifestyle isn't really going to change, then maybe that would be a reason to not consider that additional income and an award of child support, because really it is a windfall at that point.
Mm-hmm.
But absent that, if really your client is relying on that income, or your client has access to additional income that could benefit the children and allow them to have a better lifestyle, then the judge is going to always usually go in that route.
You bring up a great magic word, windfall. When someone gets a bunch of money, we kind of don't consider it income because it's not repeatable. So instead we call it a windfall. And we say, okay, well, he might have gotten a one-time inheritance payment of $500,000, but that's not happening again. Until you say, well, he's actually going to get another one and then another one pursuant to the trust. So, I mean, they're just arguments that you bring up to a judge. Family law judges aren't going to be as deep into it as this until you bring it to them. So, like, your argument is excellent. It's just, and it works perfect until somebody else brings up the right case law. But lucky for you, most divorce attorneys don't bother.
Quick question about the subpoenas that you sometimes send to the other party's parents to
Yes.
have you ever seen a motion to quash filed by the parents' attorneys, and if so, how was that?
Oh boy.
Yeah, that's a good question.
So somebody does that to me. Welcome to the party. I'm adding you as a party to the case.
Really?
Yeah, you want to play games? You're playing games in here.
Let's talk
The
about it.
family law, the Illinois Marriage and Dissolution of Marriage Act is the most liberal of anything in Illinois for including parties. We can do stuff that other courts can't. We can include anybody. We can include a nosy neighbor. We can include your boss, and that is nuclear. They're there and they have jurisdiction. Well, they have to be a third party to have jurisdiction over them.
Yeah.
So the court's going to say, okay, well, I want to see what your will. Maybe there is $1 billion there. Maybe there isn't. Instead of just being the raw subpoena power, where you're asking somebody to be in contempt for subpoena, you could get. You want to be in the part. You want to be in this. Let's be in this. And here's where it comes up all the time with parents. Parents who put themselves on the deed. The case law says that if there's 3 people on the deed and you don't say who owns what, then it's going to be 1/3, 1/3, 1/3. But it's usually, let's call it dad and daughter, and then it's 50-50. And now son-in-law really only owns 25% of the property. And in those cases, dad is getting included in that case. We will include him because it forces settlement, and we have no jurisdiction to make dad do anything with the house unless we include him as a party.
The only exception to that is if it's truly a true premarital property, you know.
Yeah,
where
that's true. And son-in-law,
you
yeah.
wouldn't do that because obviously it was,
Mhm.
you know, the dad that bought the apartment for the kid that went off to
Yeah.
college, and then that was a premarital, obviously, and what have you.
Mhm.
But if it was done during the marriage, which is usually when they'll do it, how many people do you come in, you know, during, I want to add my kid onto my property now because I want to make sure that this, that, or
Mhm.
whatever, then that's when Russell's going to come in and say, yeah, no.
And how we really handle that is we say, like, let's figure this out before we figure anything else out. We love declaratory judgments in family law, and judges love them when you bring them to them because it turns a 10-day trial into a 2-day trial because the big, hairy, sticky issue already got dealt with. And so whether a parent's gift, whether something was a gift, an inheritance, something's held in trust, almost all of these issues that I brought up today would get brought up in a declaratory judgment first if the lawyer knew what they were doing. But usually divorce lawyers just wait till the end and try to horse trade it out in the back room, which is bad practice. The better practice is to know what your real rights are and to start doing these things like including parents in the case so that you have leverage to get this case closed out on better terms for your client, no matter what these trusts say.
2 questions. One is, so Illinois, is it an inception of title state where, like, if someone buys a house but they still have payments on it, then they get married and now they're making payments out of marital money, and then there's a divorce, does he get the house but he owes the spouse something for payments that were made?
In regarding the marriage of Zito and in regarding the marriage of Snow, say that in Illinois, it's very different in other states, if you live in a house and your name is not on that house and you're married to the person, whose name is on the house, and you're paying the entire mortgage, you're paying for the garbage to get taken out, you're paying for the electricity, the water, the landscaping, you get nothing out of that house. Because the presumption is you're getting the benefit of the bargain because you live in the house. You're essentially paying rent to your spouse. You're not investing in your spouse's investment. Illinois law is extremely clear about that. In other states, which is why you want to do a lot of forum shopping if people live in multiple states. In Florida, absolutely not. If the appreciation of the house even gets counted as a marital asset.
Well, in Illinois, the husband would get the house, and whatever the wife had paid or whatever had been paid out of marital assets, that was like a gift from her that she came, she doesn't
Yeah,
pay back.
that's it.
Living expenses.
It's living expense.
Living expense.
Yeah.
Contribution
The
to
only issue
household
would be is,
expenses.
like, if you did a major improvement, you can argue maybe.
Yeah, then you got to prove that. It's
Yeah,
impo-
and it wasn't something a necessity. You built out the basement and you spent $50,000, a fancy basement, or you put a pool in the backyard with marital money, but then that's not going to give you the half the house, it's just maybe gonna reimburse you half of that expense.
Yeah, it's under a contribution claim, and case law says that too. There's always, for fairness, there's a little used statute that says the court will consider the contributions of each party, and it's little used because there's always one spouse who's like, well, I made all the money, I did all the contributions. Shouldn't I get the vast majority of the assets? Because I'm the only one. There wouldn't be anything if it wasn't for all my work. But then the counter to that is like, well, no, I was the homemaker, and I'm the one that let you do all that work. So why aren't I getting this? And so judges, for the most part, ignore contribution claims, with the exception of contributions that get commingled, such as purchase of a house with a deposit that was clearly non-marital, but now that it's in both names. And in theory, there's no bigger commingling than that. But almost every judge is going to say, show me the transfer, I'll put it back into your column, and it won't be a problem. So judges truly do the right thing. They use the statute and the case law as tools to try to get there. And so the judges usually know how they want to get there. And your job, or my job rather, is to say, well, you probably should use this tool because it gets you a little more there to where you want it, or you can't go as far as you want to, judge. Showing something and saying, you can't do what you think you can do, you better have a court reporter there, and you better make an offer of proof, because they're going to do it. Yeah.
So, this is not necessarily related to trust, but if a couple enters into a prenup in which they agree to waive their right to the statutory forced share, is
Yeah.
that enforceable?
They agree to waive to their right to the,
They waive their right.
in a
to-
prenup?
If their spouse dies, to the forced
Oh yeah,
share.
oh yeah,
So that's
oh,
enforceable?
oh yeah, yeah, absolutely.
Okay. I've heard someone else say it was non-enforceable.
They're wrong. I should have put that in the presentation. That's a great issue. Yeah.
Actually, mine was also related to that, because I get, second, third marriages coming in,
Mhm.
and they all want to have, one, a prenup,
Mhm.
and two, the question becomes, when do I plan my trust? Before we get married, or after we get married? Because I want to include my new spouse
Mhm.
in my planning. We're gonna define how we will, I will even maybe specify what I will leave her in the prenup. And then, so I generally say to people, it's okay for you to come and plan after you get married, because, you're gonna be planning with non-marital assets
Mhm.
anyways.
Yeah, that's right.
And, but now that I heard that you say, if it's during the marriage, the trust is automatically gonna be considered marital,
Well,
that's kinda.
But you have a prenup and you have premarital assets.
the prenup's a contract. You're bound by that contract. So if the contract says that you can't make a will that looks like this, and you make a will that looks like that, you're in violation of that contract. And when you're dead, they will hold you to that contract.